Good evening, Senior AMUZU.
Good evening, Doc.
Sorry for keeping you waiting. Just 2 minutes. I'm sure the students will come in and then I'll speak properly.
Okay.
Student, welcome to tonight's edition of our push towards the finishing line. When Tuesday we go to write the 2021 Ghana School of Law Entrance Examination. So as we promised you, we have succeeded in getting another distinguished lecturer in various law subjects, including law of contracts, from Gimpa School of Law, to be with us tonight to take us through as many areas that time will permit him within a very limited time that he has. He's coming from another marathon meeting, but he's been very kind and gracious that despite his tiredness, he will not turn me down. I will not turn all of you down. So I'm going to hand over to my colleague and senior, Mr. TUINESE AMUZU Edward. He's a lecturer at the Gimpa School of Law. He's a private legal practitioner as well. And because of the special interest some of you have in this LGBTI, and he has also worked in the human rights field before coming back to the academia. So when he finishes what he wants to tell us today, as an icing on the cake, or maybe like dessert, when you've had a good fufu or pele and you want to get something light, or so that you will give us some few thoughts you want to share with us on some current topical human rights issues like LGBTI, Rastafarian, and yes, anything which you want to give us a dessert, maybe ice cream or banana cake. So, Mr. TUINESE AMUZU, your students, our very good friend, Mr. TUINESE, yes. And this session, as usual, has been recorded because not everyone will get the link and join us. And even those who get the link, after hitting 300, they will not be able to come in. So we will later upload it on the YouTube for them to play it back. So Senior, over to you, Jolati.
Great. Thank you so much, Ernest. It's a pleasure to be here this evening to lead a discussion on the law of contracts. Of course, the impending exam will cover a lot of areas, and contract is one of them. So it's a good thing that we take the opportunity to reflect on all that you have done, perhaps in the last 3 years, and most often you will take contract law in the first year of your study. So it's a good idea at this point to try to refresh your memories on the key principles and the ideas behind, the principles, so you can fall on them should you have the opportunity to answer a contract-related question. Last year, there was a very basic contract question on the capacity to contract. And we do not know what the situation will be this year, but it's always the best to be well prepared before you go into the classroom. Now, having said that, as Ernest said, we don't have so much time. So my intention is to do a very quick check with you in terms of the approach which you will want me to adopt.
Mr. TUINESE, I
Yes.
think at this stage, we will leave it to you as whether you want to do the straight line approach in which you move from areas of your choice, or there are particular areas you would like to emphasize. So it's entirely freestyle, it's up to you. Anything, yes.
Okay.
Thank you, Senior.
Okay, thanks so much. But also, fortunately for you, you are not one of the people who will be writing the exam. So all right. I would like.
Okay. So students, you raise up your hand and then we release you to talk. Yes.
Yes. So I want to hear from them. I mean, I can run through very quickly almost all the topics. I can run through very quickly. And then we come back to a question and answer session. I also like to use multiple choice questions a lot to teach. So I have some which we can experiment with. So that's one option as well. Run through the course, lay emphasis on certain areas, and then project some of the multiple choice questions, and we can try to use them as teaching tools for the evening. That's, if you leave it to me, that's what I will do. But I believe the students may have some ideas. So
look at the chat. Some of them have put some things in the chat. Maybe if we click on the chat. Yes.
Okay, good. So far, it appears there is unanimity to run through everything, which is actually a very tall, a very tall order. Okay. 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 The whole show. Okay. All right. Okay. All right. Okay. But obviously, you know that if we are doing the whole show, we are not going to be able to cover everything into details. But let's attempt to run through everything very quickly, and then we'll come back to the multiple choice questions, because for me, they are very interesting, and sometimes I set them in a manner which makes them make them very controversial. So it's always interesting to see students trying to resolve these multiple choice questions and come to a conclusion as to which of the answers is best in this circumstance. Now, so with this, with the unanimity on running through everything, let me project some slides. I'm going to project four slides, which may cover everything. I will do that maybe in an hour and a half, and then we come back to have a discussion. Okay. Okay, so this is what I had explained as what I will do if you leave it to me, and it appears we're all aligned on it. So this slide will cover some introductory matters, particularly what I call recurrent themes, some theoretical and recurrent themes in the law of contract. You will know by now that once you are in a contract class, from day one to the end of the year, certain things just cut across and jump at you anytime, okay? The ubiquitous nature of what is referred to as the objective test, for instance, is one thing that you can never go wrong with if you really understand it very, very well in a contract class. Okay, it is just part of the course from day one to the end. The need to rely on the objective test in resolving problems. So this slide will deal with issues around offer, acceptance, intention to create legal relation, capacity to contract, and privity. Now, so these issues which I refer to as the recurrent theme include the fact that the offeror is the master of his offer. And this is very crucial for me, because if you are to be deemed to be accepting an offer, then you must be responding to the terms of the offer. If the offeror says, pay by check, as a general principle, you must just agree to pay by check to be responding to the offer which he has made. That also links us to what is referred to as the mirror image rule in offer and acceptance. The mirror image rule in offer and acceptance, which is simply the requirement that in order to accept the offer, respond in a like manner to the terms expressed in the offer. Okay, so the mirror image rule. Of course, this is not always, the mirror image rule is not applied in its fullness all the time. Like several other principles in the law of contract, you will have exceptional situations, okay? One of those exceptions being situations in which some of the terms are inserted for the purposes or in furtherance of ideas of the intending or potential offeree. So if he doesn't respect the mirror image rule with this understanding, he may not necessarily be found wanting. He may not be deemed not to have accepted the offer or to have rejected the offer. Of course, you know, contract is part of civil law, so we don't need to waste time on that. Yeah, meaning of contract and so forth, we don't need to waste time on that. Broadly speaking, I mean, the reasons why the courts will enforce a deal are important to keep at the back of your mind, so that when you have conflicts in some of the principles, you may rely on some of these general ideas to resolve it. If the objective test it's failing you and making it difficult for you to reach a decision. Okay, so the importance of tying down deals for the future, and the fact that this will help everybody to plan, to make transactions predictable. Okay, it's important to keep in mind. The fact that enforcing a deal responds to our notions of fairness. Okay, the fact that if your word must be your bond. Okay, so whatever you have agreed to, you must perform in keeping with the that Latin maxim pacta sunt servanda. The fact that in the absence of these principles which guide our relationship in terms of contracting, if we do not apply these principles, we will be living in the jungle, where a life of the jungle where survival of the fittest will be the name of the game. Okay, kind of taking us back to what is referred to in jurisprudence as the state of nature. Okay, I believe that must have been Thomas Hobbes. The state of nature where there will be war of all against all.
It's 7 o'clock.
Okay. Now, you should also keep in mind that what the courts do in contracts is to defer, by way of enforcing the deals, is to defer to the parties. Okay, the court, in a very technical sense, consider themselves to be incompetent to replace the terms which have been agreed to by the parties. Okay, so keep also that at the back of your mind, that the court defer to the contracting parties in terms of what they will want to enforce. Okay. So these are some more of the what I refer to as the cross-cutting themes. The need for the contracting parties to beware. So it is not just caveat emptor, but it is also caveat vendetta. Okay. The fact that the law will want to protect an innocent third-party purchaser for value, that's also important to keep in mind. Intolerance for fraud as far as contract is concerned. Now, having said this, you know that to have a contract, you need to have an agreement. And to have an agreement, you need to have an offer. That expression of the willingness to be bound by the terms expressed by that party who is referred to as the offeror, which terms must be definite and final, leaving no significant one of those terms up for negotiation. Typically, contract teachers will start, talking about these, citing the Khalil and Kabolik Smokeball Company Limited. Of course, we are Ghanaians, and haven't relied on this case for so long. We know we have some local cases, or rather domestic cases, instead of saying local. We have domestic, cases, which have also explained to us what we should understand an offer to be. So I typically will start with NTHC versus entry, in which Justice Databan took his time to explain to us what really an offer should be understood to mean. So you can rely on this if you need to answer a question on an offer. But of course, you will not go wrong relying on Khalil. This is the Kabul Mobile Company as well. So at least you have these two cases and more to rely on in answering your questions with respect to what an offer is. Now, recall that even at the time of explaining what an offer is, it is crucial to have terms. And we need to understand terms to be those statements which delimit the scope of the rights and obligations of the parties to a contract. They may come in the nature of the subject matter, in the nature of the price to pay, in the nature of a location of the subject matter, in the nature of the mode of payment for the subject matter of the contract. So the focus really, in order to have an offer, is on the terms. It is the terms which must be definite and final. And it is this definitiveness and finality in the terms which makes a difference between an offer and what is not an offer, what may be referred to as an invitation to shafa or an invitation to treat. Okay, so bear that at the back of your mind, that it's important that the terms are definite and final, and that the terms delimit the scope of the rights and the obligations of the parties to a contract. I'm going to jump this. Then we talk, very briefly about the types of offers, which leads to, the types of contracts which we may have: bilateral and unilateral offers. Something to highlight here is the withdrawal. Okay, the withdrawal or the revocation of a unilateral offer. Okay. Question is, at what point is the offeror at liberty to revoke a unilateral offer? Of course, generally, we know that the offeror is at liberty to revoke the offer before the offer is accepted. But when we talk about unilateral offers, you know that it is the act which the offeree is expected to perform in response to the offer, which act may also qualify as the offeree's consideration, which will be the offeree's acceptance of the offer. Okay, so ordinarily, before the offeree tenders that acceptance, the offeror should be in a position to withdraw ordinarily. But you can also envisage a situation in which it will be unfair for the offeror to see the offeree on his way to perform, almost, at the end of the race to perform, and the offeror will say, no, I have withdrawn the offer. Okay. So typical example I give is you can have a unilateral offer which says, my dog is lost. If you look if you bring it to me, you are entitled to $100. So if I'm standing on my gate and I see you coming with a dog, am I at liberty, to say, hello, sorry, I have revoked the offer because you have not brought to me the dog, when we can see that you are almost at my gate to give me the dog? Okay, so because of this, there was this statement which in Arrington versus Arrington, which has been extended by lawyers and law teachers to mean that when the offeree starts performance, in a unilateral contract situation, the offeror is not at liberty to put impediments in the face of the effort being put in place by the offeree to fulfill the requirements of the offer. Recall that in this situation, what I referred to much earlier this evening as a recurrent theme, that the offeror is the master of his offer, will also come to play, because quite often it is possible that a unilateral offer will be made in such a manner that it may be capable of being accepted by a lot of people. If that is the case, it is the offeror's headache. If he wants to contract with one and only one person, he should be in a position, he's in a very privileged position to render the terms of the offer such that it is only capable of being accepted by one and only one person. You could say the first person who brings the dog, okay, then that is it. Of course, you can go back to the Khalil versus Catholic Small Ball Company for a lot of authority regarding how even as an advert is placed, which could be, capable of being accepted by the whole world, that could still amount to an offer. Of course, you will recall that cross offers don't amount to acceptance. And you also will recall that when you're talking about revocation of an offer through the post, then the usual rendition of the postal rule does not apply here. I will deal with that a bit more when I'm discussing acceptance, which is just here. Of course, we can just jump into what I just started talking about and even complete. Recall that much earlier in the 20th century, the post was a very fashionable way to engage in business, to contract. Okay, things have changed so much from that time. Now we have the benefit of several other forms of media through which we can contract. But the post used to be an important medium through which, an offer could be expressed and an offer could be accepted. And so there were rules developed around the use of the post, okay, and in acceptance, okay, in trying to accept the offer. So the rule properly rendered is that if it is within the contemplation of the parties, particularly the offeror, that the post is an appropriate means by which the offer can be accepted, then once the offeree properly indicates his acceptance, his assent to the terms, and drops it, properly addresses the envelope and drops it in the post box, acceptance is effective at that point. So it is not just a statement which says that, well, once you put the acceptance in the post box, acceptance is complete. No. The important thing to bear in mind is that it must be within the contemplation of the parties, particularly the offeror, that the post is an appropriate mode of acceptance of the offer. And the prospective offeree or the offeree at this point must also play his part by properly expressing his assent and properly addressing the envelope. And once he drops it in the post, then the acceptance would have been complete. Recall also that an acceptance is an unqualified expression of assent. So in order for an expression to qualify as an acceptance, it doesn't have to be qualified. If it is qualified, by qualification, we're talking about ifs, buts, maybe. All right, if you have these kinds of expressions, it may not necessarily come in these words, but the substance, if the substance of it communicates an uncertainty, okay, an ambiguity regarding the expression of assent by the prospective offeree, then that will not qualify as an acceptance. Okay, so an acceptance must be an unqualified expression of assent which must be communicated. And as you will recall for Fofier versus Zanyo, there's nothing like a mental acceptance. In that case, it was stated that a mere mental acceptance will not amount to an acceptance. Okay, so an acceptance must be communicated. It's very, very crucial. And it must be unqualified. Okay, the expression of assent must be unqualified. When you have an offer, a number of things can happen. You can accept it, which means that you have expressed your consent in an unqualified, you have expressed your assent in an unqualified manner, or you can propose terms in response to the offer. Okay, new terms in response to the offer. That will then amount to a counter offer. Or you can flatly reject the offer. Flatly reject the offer, okay? And you can reject the offer just by saying you are not interested. That's a rejection. Or you can make a statement which shows that you have not accepted and you have not proposed new terms, okay? So just like it happened in Debe versus Insian, okay? That statement that being very good friends, I hope you will reduce the price, was treated as a rejection and not a counter offer. So you need to draw the distinction between a rejection and a counter offer, although the effect of both of them is to extinguish in perpetuity the power of acceptance which has been created in the offeree by the offeror. Okay. Now, what else can happen when you receive an offer? You can also inquire. You can make an inquiry. And the inquiry can happen before an acceptance or after an acceptance. And remember that the inquiry will not be treated as an acceptance and should not also be treated as a rejection of the offer. But there's a very thin line between making an inquiry and making a counter offer. So for instance, if the a term of the offer is that pay by check or pay cash in one installment. And then the expression from the potential offeree is, would you accept check in 2 equal installment payments? This appears like a question, but in substance, it's introducing new terms. Okay, it's introducing new terms. So for a question like this, it's likely that it will amount to a counter offer. But if he says, okay, you want me to pay by cash in one at a go, you know, could you please furnish me the account details? That's a simple inquiry, just like you saw in NTSC versus entry. Okay, so bear this also at the back of your mind. Now, an important thing that I wish to emphasize, I mean, if I were somebody who should contribute to setting your question for you, this is an area that I may set a question. Is on electronic transactions and the effect of that on offer and acceptance. Recall that we are in an electronic age now. You can receive an offer by WhatsApp, I mean, through Skype, through Hangout, through all kinds of electronic media. Okay. And the electronic media certainly has implication for what our understanding of the traditional understanding of the dispatch of an offer and the reception of an offer. The offer needs to be dispatched in the first place and must be received in order for us to start talking about acceptance. Okay, so if these expressions are moving in the electronic realm, what are the rules? Okay, what are the rules? You will find the rules in sections 18, sections 19, and section 23 of the Electronic Transactions Act 2008 Act 772. Okay, take your time to read these rules and be sure that you have clarity on them. You can just get back to them again. I'm sure that you must have read them much earlier, but get back to them again. But section 18 is on dispatch of an electronic record. And so the question is, when will an offer be deemed to have been dispatched? The rule is that if the that electronic record leaves the originator of the record and enters into an information system outside of the control of the originator, then the originator has dispatched the electronic record. That's the first thing. Okay, so the operative part of this rule or of this principle is that it must be, the electronic record must have reached an information system out of control of the originator of that information. Okay, so it raises a difficult question as to recall